5, 4, 3, 2, 1. Start. Summer holidays for courts have long been a tradition rooted in colonial legacy, but in the current societal and judicial framework, they raise several concerns. The modern judicial system is burdened with a massive backlog of cases, some of which involve urgent matters such as bail applications, family disputes, property issues, and constitutional challenges. At such a time, the idea of courts shutting down for an extended period creates a vacuum in the delivery of justice. This delay not only affects the parties directly involved in litigation but also undermines public confidence in the judicial process. When access to courts becomes limited due to holidays, the most vulnerable segments of society suffer the most, particularly those who are under trial and awaiting decisions that may impact their freedom or livelihood. The argument that courts need rest during summer may have had relevance in a time when climate control and infrastructure were inadequate. However, the present-day courtrooms are increasingly equipped with modern facilities. Moreover, professionals across other demanding sectors, including doctors, engineers, and emergency service workers, continue to perform their duties without long collective breaks. When society depends on a particular institution to uphold rights and resolve disputes, that institution cannot afford to be unavailable for a long duration. In that sense, summer holidays for courts appear to be out of sync with present-day requirements and societal expectations. An important aspect to consider is that justice delayed is justice denied. Every day that a matter is not heard due to court closures adds to the already growing pile of pending cases. There are thousands of individuals across the country waiting for years to get their cases heard. While higher courts may continue to function through vacation benches, the functioning is significantly limited and selective. Many urgent and sensitive cases remain unaddressed, forcing litigants and lawyers to wait for the reopening of the regular court. This not only delays justice but often leads to increased legal costs, procedural complications, and emotional distress. The long wait for hearing dates and orders further creates a sense of frustration and helplessness among common citizens. It is also worth noting that in a democracy, courts act as a guardian of individual rights and liberties. Their unavailability, even temporarily, means that for that duration, citizens are left without an effective remedy. In cases of illegal detention, police excesses, eviction, or child custody, time becomes a critical factor. A delay of even a few weeks may result in irreparable damage or injustice. The inability of litigants to approach courts during such crucial moments weakens the faith of people in the judiciary. Moreover, courts are also expected to function as a check on the other branches of government. If courts remain shut for a long period, executive and legislative excesses may go unchecked, leading to a possible erosion of democratic accountability. Another consequence of prolonged court holidays is that they create a bottleneck in the court calendar. The sudden pause in proceedings results in a heavy pileup of hearings once the courts resume. Lawyers are then compelled to handle a congested schedule, often appearing in multiple courts within a short span of time. This leads to stress and inefficiency, both for advocates and judges. The purpose of a vacation, which is to promote rest and mental rejuvenation, ends up backfiring when the workload increases sharply post-reopening. The quality of justice delivery suffers when cases are rushed or adjourned due to excessive burden. Instead of offering relief to the judiciary, summer holidays often shift the pressure to a different period, thereby defeating the very purpose they are meant to serve. There is also a growing public perception that court holidays serve the interests of a privileged section and not the average citizen. The idea that a critical public institution such as the judiciary should close during summer is being questioned by more and more people, particularly those from remote or economically weaker sections who rely on quick resolution of their legal problems. For many, the court is not just a place of law but a lifeline for survival, dignity, and protection. Shutting the doors of justice during a particular time of the year, therefore, seems both impractical and insensitive to the ground realities of society. Some argue that individual judges, like any professionals, deserve personal time for rest and reflection. This is a fair point and must be respected. However, the solution does not lie in shutting down the entire system. A rotational vacation model could be adopted, where benches continue to function throughout the year, with judges availing leave at different times. This would ensure continuity in hearings, especially for urgent matters, and would also reduce the backlog over time. Such a system is already in place in many other jurisdictions across the world, where courts operate year-round without collective closures. The present structure also impacts legal professionals, particularly those who are dependent on regular court appearances for their livelihood. Junior advocates and small practitioners suffer financially during extended holidays as they do not receive fees unless they are appearing in court. While senior advocates may use the time to take a break or travel, a large section of the legal fraternity views court vacations as a period of economic hardship. This unequal impact further reinforces the need to reconsider the tradition of collective summer holidays and move towards a more inclusive and equitable model. The responsibility of the judiciary is not just to interpret the law but to ensure that justice is accessible, affordable, and timely. In a system where delays are already a major concern, taking long breaks sends a message that the need for institutional comfort is being prioritized over the public good. The call for reform is not about denying rest to judges or overburdening the judicial system,